What I can say without going too into it is that this year has been full of the highest highs and the lowest lows of my life. And I see so many women around afraid to speak, especially right now, afraid to share their experiences. And fear is by design. It's violent. But I also acknowledge that many people don't have the opportunity to speak. So I do feel fortunate. And it's the women who have had the ability to use their voice that's kept me strong and helped me in my belief in my fight for the world to be safer for women and girls.
Hi, besties. Blake Lively and Ryan Reynolds are now pivoting. And I have already decided that everything about this legal case is a pivot. It's a pivot from one excuse to another, from one theory to another, and one way to every single step of the way not take responsibility for their own mistakes and instead play the victim. And this pivot was made clear in a new oppositional filing to Perez Hilton's motion for a protective order. Now, Perez was seeking judicial intervention, asking the court for a protective order and telling the court that Blake Lively shouldn't be able to subpoena anyone again without judicial notice and getting leave from the court. And he stated that it was because she had served all of these different subpoenas that were overbroad and intimidation and harassment and all of these things. And unlike other people that had filed motions for protective orders, the judge granted this into the docket and he gave Blake until yesterday to respond. And Perez did a whole reading of his document, so I'm not going to read all of it. And to be clear, Perez denies all of the accusations they make about him in this document. In this document, they basically claim that he's working as a paid shill for them and that his job for Wayfair is to seed content for them and to manipulate, and he's being paid or he's not being paid, whatever, whether indirectly or directly. She's trying to claim there's a contract here that exists between Perez and Wayfair, and he's doing their work for them by manipulating social media, by spreading defamatory stories about her. Now, love Perez or hate Perez, I know that he's a polarizing figure. He has always been so nice to me, and he and I have always had a very completely courteous relationship. So he does his own thing, and he makes me laugh. I mean, he's the kind of journalist that is the old school, I would say, where they came up with like catchy names for people when they wrote in the newspaper and like zingers, or like those news anchors that back in the day they'd have these like catchy names for people. He does stuff like that. And he does a mix on his videos of keeping things like to the report and then adding his own commentary and then also his opinions and keeping it entertaining, which is literally something we all have to maintain. Like, you guys come to our channels not only for our reporting, but because we're supposed to be trying to entertain you a little bit. But her new pivot isn't that there wasn't a smear campaign, okay? It's now that she's being deprived of the discovery because everyone is claiming privilege for documents, or people deleted evidence, or people misplaced evidence. There's not an option that the evidence doesn't exist, right? There's no admission that it could possibly not exist. It's an excuse that she's being deprived of evidence to make and prove her claims. And when I saw this, I almost was like shaking my head, but I guess I shouldn't be surprised. And incidentally, because Wayfair is denying denying Blake documents related to a privilege log, she found one person on a text chain that was part of a conversation on their privilege log. And now she's going to that person, Skyline in Texas, and she's trying to get the privileged documents from her, claiming this person has no privilege and she can't assert privilege. So she's still to this day trying to get privileged records. So she was denied from the records from Liner because they don't have them. She's being denied from Wayfair because these were legal strategies and legal conversations with attorneys. So she found one person in the chain of the emails and she decided this person wasn't repped by them. And so therefore it's not a privileged conversation. And so she wants the document from them. I mean, talk about trying to go through a needle in the haystack to circumvent privilege. Anyway, that's a whole story for another day. But what I want to talk to you about right now is what she did with this Perez case, because like yesterday, I found a little needle in the haystack that you might be interested in. So she's really triggered by his titles and the names that he uses for her. And some of you guys use these names, and some of you people, and some of you, the content creators, have catchy names. I've never been good at that stuff. But she says that he uses disparaging and insulting names such as Blackface Blake, which she admitted to doing, Lying Lively, which she has also admitted to doing, at Ku Klux Khaleesi. Ooh, I haven't heard him say that. Litigious Lively. Parodies. Those are parody names. It's no different than them doing the nice pool. Can we like insert "you can't be sued over hurt feelings"? And then his titles are Blake Lively's non-existent smear campaign falls apart. Blake Lively is so unethical. Blake Lively the bully. Justin Baldoni exposes new Blake Lively lies. This is savage. Don't believe the Blake Lively lies. Justin Baldoni had nothing to do with Jenny Slate's complaint. Blake Lively lied. Blake Lively is trying to silence Justin Baldoni. He's afraid. Most of those actual lines are coming from, some of them are actually coming from documents that he's talking about in his videos. And he finds ways to make engaging headlines that are actually not too far off the mark of what he talks about if you actually watch his videos. But getting back to the fact that she's extremely triggered by his titles, they turned this motion for a protective order into a cross motion to compel, even though he filed his motion to quash in Nevada. So she's circumventing the courts in Nevada and demanding compliance in New York, even though the subpoena demands compliance in Nevada. So she doesn't really answer the issue, I guess, of the protective order. She doesn't really go there. She spends most of the time talking about the motion to compel. But there's a part on page 15, and it actually references something that he put into his complaint, into his motion for protective order, which was a screenshot of a post that I made on Instagram. Okay. So she claims, it says, Mr. Hilton's argument that the subpoena imposes an undue burden is insufficient to show that it is improper. The only evidence Mr. Hilton identifies an unverified screenshot of another non-party's social media post claiming to have spent more than $5,000 on legal fees is neither competent nor probative evidence of an impropriety by Ms. Lively. The court should not require Ms. Lively to seek approval prior to issuing third-party subpoenas because the record is barren of any evidence that she issued subpoenas improperly. Have we talked about Van Zan Sham? But this is clear. This is why she's doing those moot, right? So the reason why what I was saying last week is agreeing to withdraw the subpoenas, because if she loses, a subpoena is quashed. If it's quashed, that looks like she's issuing subpoenas improperly. Okay, she's had several subpoenas quashed here. She had the subpoenas to the phone companies, which he said were overbroad and invaded people's privacy. She had the subpoena quashed for Liner. He did that last week, or just this week. He quashed the subpoena for Blake's subpoena to Brian Friedman's office, most of it. She's would have had these subpoenas quashed by us had she not withdrawn them. So it's not exactly true that it's barren of evidence that she's issued subpoenas improperly. But that point there is that an unverified screenshot of another non-party social media post claiming to have spent more than $5,000 on legal fees. There's a footnote there that says, as the court is aware, Ms. Lively issued third-party subpoenas to discover connections between the Wayfair defendants and specific content disseminated through platforms such as YouTube and X and has withdrawn certain of the requests after conferrals, reviewing motions to quash, and other public information. There is nothing harassing or improper of such a process. Okay. I did get a bill today. I can't show you all of it because it would be attorney-client privilege, but I can tell you that I received a bill today for a total of $55.80. And the title of the bill is for the Blake Lively subpoena. So in a matter of 2 weeks, I racked up $5,500, almost $5,600, dealing with Miss Lively. And some of those were dealing directly with her attorneys. And her attorneys telling us that I was part of the smear campaign. They knew I was being paid by Mr. Baldoni and they weren't going to withdraw. That was like the first conversation. And then turning into, as people started putting things on the docket about us not being connected, and my legal team saying, no, 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 she hasn't been paid by anyone. She has nothing to give you. No offerings here. She's not being paid by anyone. She is a independent journalist. And then suddenly they withdrew it. But during that time, they never identified a single post, a single statement I made. Like generally, for the most part, and I've had this happen in the past, if you get a cease and desist or a subpoena or you're sued, they will tie it to specific statements that you made. Okay. She didn't do that here. We asked her for a specific video I made, a date of the video, a date of the post, a date of the statement that was said, anything. And what her evidence was that somehow it was tied to Wayfair, and she really didn't have anything. And then she agreed to quash or withdraw the subpoena, but then was like, well, we need you to confirm that you don't have any anonymous sources that reached out to you. And those anonymous people are, you're disseminating information for them. Like some untraceable person that I can't find, like it's Watergate. And he's calling me through a can and a string from the attic. They live in a movie constantly, I think, but it's not unverified. I don't put out things on my social media that I can't back up. And if I do, I correct it. But I actually ended up spending more than 55. That was just one bill. My other bill I paid 2 weeks ago is $3,300. So in total, I spent almost $10,000 on the 2 weeks there of Blake Lively harassing me. Okay. Regardless, I want to get to the part now where she does lie about him a lot. She tries to to get around privilege, just like she went with trying to get around privilege with Brian Friedman and saying that Brian Friedman was a PR agent. Now she's saying that Perez Hilton is actually not a journalist, he's an influencer, and that he was identified on a list by tag. And they're using their definition, the definition they came up with, not the definition that is an actual definition of what a content creator is. But they're claiming that he's an influencer. He's not a journalist, but they are also saying that he is seeding, generating, creating, or influencing content. And he's doing so digital or social media services directly or indirectly at the request of or on behalf of any Wayfair party or their agents or affiliates. That's the problem with their definition of what a content creator is, because that's not what a content creator is. That's probably what they think content creators are, because it's probably what they do. They probably provide information to people and have them seed it out there that way. They have Leslie Sloan, who loves to plant and seed and generate crap about their friends and plant stories about Blake that are positive. And the reason they claim that he's not an independent journalist is because he doesn't reach out to her side for comment. Here's the problem with people like Blake, who has a huge team around her and who works in the world of celebrity. Creators and independent journalists like me could send a request for a comment to her PR, but most of us don't know how to get in touch with Leslie Sloan. And when speaking on and reporting on public records and court records in matters of public interest and that are on a public court document in a federal court, ethically speaking, the journalist does not have to speak to either side. And so he can go to the docket like me, right? And he, like me, can pull up a docket, right? Go to Pacer or go to Court Listener, however you get it, and you can read the court record and you can summarize it and put it out to the public and report on it and share your insight or, do some further research. But legally speaking, you do not have to speak to a public figure when they are involved in a court case. It might be beneficial. It could be maybe more balanced or comprehensive, but most celebrities are not going to comment on their public lawsuits. And you don't have to have consent from that person to speak about or report on the public document because the court record is public, the case file is public. They're open to the public, including you, not just journalists, but you. And reporting on outcomes in court is actually considered a matter of public interest because it allows you, the public, to better understand the legal process and it allows the public to hold public figures accountable. The only time we are not supposed to speak on things if things are sealed. So we don't get access to information that's sealed. And we certainly could try to reach out for comment. But a lot of what most of us are doing is pulling the record, giving you your daily update that you come here for. And then we share the history of the case and then we move on to the next video. So their argument from a legal perspective doesn't match what's the actual practice in journalism. And here in journalism, you're not supposed to cause more harm to a subject. So you're supposed to minimize harm, right? But with public figures, it's completely different. So technically speaking, any public record is public, right? So if I wanted to report on some random person who lives down the street from me and just start pulling their public records, I could, but they're not a public figure. So that could actually technically be viewed maybe as an invasion of privacy to the extent that you're unmasking someone who's not who's private and then you're making them public. But in a case of this, where she's a public figure and she goes to a court and files a public record, which is a court document, and then takes that public record to the New York Times and spends weeks working with them to publish a document and to publish a story that goes on their front page, and then gets mad if Wayfair speaks to a journalist, it's kind of hypocritical, right? Because sure, Megan reached out to them, but she gave them like 2 seconds to respond. And then Megan, what did she fall back on? One of the times arguments to the court was, well, technically, when it comes to public records, we don't have to ask for comment from anyone. And they're not lying. They don't. But in this case, they relied heavily on Blake's side and then they didn't go to the opposing side. So it's kind of like they're accusing Wayfair of doing what they did. Every accusation is a confession. When Perez was reading that part, he said kind of the same thing. He also completely denied doing anything for Wayfair. And he said he's not in the business of helping shape narratives because they said Mr. Hilton is in the business of shaping narratives for clicks and profit, not informing the public. Isn't that what Blake did with the New York Times? So really what their whole legal argument here is to try to get around the New York Shield law. And they're trying to say that he doesn't have privileged in any way. But this is the part where they're going to pivot. And this is what I'm going to predict. This is my prediction. And I don't know if it's true, but I like to try to give you some things that to sort of marinate on. But I do think that the next excuse is if they don't get the evidence of a smear campaign, they're going to start accusing people of deleting evidence, destroying evidence, or losing evidence and being deprived of evidence. So here's what she wrote. The Wayfair defendants have at every turn refused to provide such information voluntarily and insisted that Ms. Lively considerable resources fighting objections and litigating her entitlement to these communications because he's apparently been trying to get communications with content creators for 6 months. But if you recall, back in, I don't know, it was 2 months ago maybe, Wayfair did put out a record and they put out their interrogatories and they said that they didn't have communications with content creators. There wasn't any to give. And do you recall that she wanted them to say, do they give them scripts? Are you giving them access to that email where they can see a script and then they report that script? And they said they don't do that. They had nothing to give. But instead of accepting that the word none It's being framed as they have refused to provide. If they don't have anything to provide, they can't provide something. To date, Miss Lively has received virtually no communications with content creators and none with Mr. Hilton, despite the fact that neither Mr. Hilton nor the Wayfair parties have denied their existence. None of the Wayfair defendants have produced any signal communications, notwithstanding admissions to using, and it's redacted, which leads to strong possibilities that the Wayfair defendants have deleted, destroyed, or lost evidence. The refusal of the Wayfair defendants to produce or perhaps to retain such communications, combined with this motion, amounts to a shell game that risks depriving Miss Lively from discovering pertinent information about the retaliation scheme. While Miss Lively has filed a motion to compel the production of such information, time is running low with the document discovery 10 days from closing. Under these circumstances, there is no basis for requiring Miss Lively to continue incurring expenses attempting to identify what party or third party has possession, custody, or control of the communications and compel their production to multiple courts when there's no question that Mr. Hilton possesses them. Okay, so he put out a statement. I think he put out a statement from Friedman once. And I think it had to do with he's actually had a couple times where he's put out a statement from their side. Seeking comment from a side isn't against the rules. And if he goes to the one party and seeks a comment and it's based on what that one side did. So in, for instance, getting a comment about why they didn't file amended complaints, a second amended complaint, or if they were going to appeal. In that case, you don't need to go to both sides. You're just going to a comment of the one person that you're talking about, right? And a couple times he's had comments that were given to him that were statements from the legal team. I don't believe that that would constitute, having these communications. But I want to circle back because it leads to strong possibility that they deleted, destroyed, or lost evidence. She's accusing them of spoliation, which is a crime. But this is something that she's been accused of doing because Wayfair, if you recall, claimed that Blake was seeking to have Taylor Swift delete her texts and had told other people, potentially cast members, to also delete their communications. But she's sort of flipping that. And now it's, well, they must have deleted or destroyed or lost evidence. Here's the thing. If you're not a part of litigation and there's no threat of litigation, so if you have not been told by anyone that you cannot delete or destroy evidence, or that would be grounds for, contempt of court, spoliation, all of that, you're not actually required to keep anything. So if you're not in a lawsuit, and at the time that a lot of the stuff was going on, no one was sued, no one was being sued, there was no demands for their evidence to not be destroyed. In fact, her first demand letter to them was filed in December of 24. So up until December of 24, no one had to keep anything. They didn't. They really didn't. And if they are like me, I go into my inbox, my emails every day and delete them. Some things I don't delete, like I don't delete text messages. I don't delete screenshots a lot of the time. Like I have 100,000 photos. There are some things that I do keep, but there's also social media platforms like that have disappearing messages. So if you're on a Signal chat and the messages disappear, they're not really deleting anything. It's just the messages are disappearing. So there's not a trace of the conversation. If they spoke on the phone, there's not going to be a footprint of that. There would be a call log, but you have no idea what they were talking about on that phone. And you can't record someone's phone call in the state of California without their consent. So really, nothing was deleted if it wasn't there, if they weren't required to have it. Having something deleted doesn't mean anything. Destroyed suggests that they're willfully not providing something, or they lost it. All right. Or they just don't have it. That's not a possibility. Leads to a strong possibility. One could be that they just don't have it because it doesn't exist. And just because you use Signal doesn't mean that anything on Signal is bad. A lot of people use Signal because it's encrypted and it's secure and it's safe. And you can also speak to people internationally without having to pay international fees. It's kind of like WhatsApp, but more safe than WhatsApp. It's a way to not have to worry about getting hacked. Some people get very uncomfortable using social media, so Signal tends to be a little bit safer. End-to-end encryption, less likely of being hacked. They have methods for communication. You can do calls on Signal, so it's not just if they're doing a call, there wouldn't be a message because the call is not recorded on Signal, but it's a way to talk on the phone too. It's like WhatsApp. You can call someone from Signal. And if Signal has the ability to have messages disappear, nobody's deleting anything. It's just that the messages are only held for X amount of period and then they go away. And using that doesn't imply that anything bad happened. It doesn't. People want to have the ability to talk confidentially without fear that they're going to be spied on or have something, revealed to someone else. And when you're a celebrity and you have a lot to lose, you want to use resources that protect your privacy. So using Signal doesn't mean they did anything wrong. Communicating on Signal doesn't imply malice. It's just a safer way for them to speak. It doesn't mean anything was deleted or destroyed. And they can't give her what they don't have. They've already told her they don't have communications with these people. And Wayfair has already told them that the only communications they've had with these journalists or these content creators is issuing them statements that are the same statements that People Magazine puts out, the same statements that, TMZ puts out, New York Times, whoever's producing that statement. So, what she's going to pivot to now is the reason why they can't prove the smear campaign, because that's going to happen, is because they deleted and destroyed evidence. And they layer this on a possibility so it doesn't look like it's an actual defamatory accusation. And they're making her a victim of them because they are denying her evidence, even though they claim that they have it. But again, saying that you were on Signal doesn't mean that anything you did on Signal is bad. I'm in a group chat on Signal with some content creators that cover Blake Lively, and I can tell you we're doing absolutely nothing there that is malicious. So the pivot is I can't prove a smear campaign, so now I'm going to blame Wayfair for deleting evidence and misusing privilege. And so at the end of the day, when my case falls apart, I'm still going to blame them for having a smear campaign. I just couldn't prove it because they deleted evidence. That's the spin today. So what are your thoughts? I can't wait to see what Wayfair's response is to the motion for sanctions. I'm also eagerly waiting for them to respond to her 2,000 pages of her motion to compel, which they've sought an extension for. And I can't wait for them to respond to Blake Lively's hissy fit about the deposition. Brian Friedman must have really pissed her off for her to have this kind of reaction. All right, y'all, let me know what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.